So, so thank you all for coming to this today. I'm Nick Rishwain, Vice President of Business Development at Experts.com. Our guest and workers' compensation personal injury attorney is Bernard Nomberg out of Alabama, Birmingham, Alabama. Bernard has practiced civil litigation in Birmingham, Alabama since 1995. Bernard received his undergraduate degree in history from Vanderbilt University in 1990, where he also played football on a full athletic scholarship. He then graduated from Jones School of Law in 94, and his practice concentrates on workers' compensation, Social Security, and personal injury claims. Bernard, thanks for being here today. Bernard, I will also say, is a good friend of mine. So I'm really grateful for him taking the time to join us today and to inform us about independent medical exams, much of which you deal with on a regular basis in your practice, correct, Bernard?
Good morning or good afternoon, Nick. And yes, we do deal with it quite a bit. Thank you for the introduction.
Oh, my pleasure. My pleasure. Thanks for being here today, Bernard. So again, everybody, we're going to get started on independent medical examinations. This will be recorded, and the recording will be available on YouTube afterwards. So if you found something that you really enjoyed or something that you'd really like to brush up on, we'll have that up in a day or two with links to Bernard's law firm as well as to Experts.com. If you have any questions, rather than putting them in the chat, if you could please put them in the Q&A section. We'll try and leave about 10 or 15 minutes at the end for Bernard to answer some questions. And we'll go ahead and get started. Bernard, you just tell me how you'd like me to go on the slides when you're done covering one, and we'll have a little bit of conversation in between, answering any questions. And on occasion we'll take a question during. If you feel like it's really important, go ahead and put that in during. But there will be some conversation and examples from Bernard's experience. So just tell me what you want me to do from here, Bernard.
Very good, Nick. I sure appreciate the introduction, and welcome to all of you who are with us from wherever you are. I'm taking the approach with today's discussion that those of who are in our audience have not done but are interested in independent medical exams from different types of cases. The history, or where I come from, is I deal with workers' compensation, Social Security disability appeals, and personal injury cases. I will preface what I'm about to talk about over the next 30-40 minutes is I practice in the state of Alabama and only in Alabama. I do not know different states' specific rules, regulations, or laws. Most of what I'm going to talk about, though, can be transferred to really any state where you're going to practice. But if you are hired or if you are brought into a case in your particular state, you do need to be familiar with what the rules, regulations, and laws, particularly if any of you are familiar with the Daubert federal set of laws when it comes to the hiring of experts in cases. You're going to need to familiarize yourself, but we'll get into that in just a few minutes. Like Nick said, I've been practicing for more than 20 years doing work comp, Social Security, and personal injury cases. And I have come across really three different times or three different occasions when IMEs, independent medical examinations, are brought up or utilized in my cases. You can be asked by one of the parties to a case. An example, let's say that it is a workers' compensation case and the medical condition that's at issue has not been approved by the work comp carrier, so there's a dispute between the parties. The plaintiff, the injured party's attorney, may hire someone to give an independent medical exam, but I do want to preface, the term independent really is very important here. And again, every state's a little bit different. but sometimes one party, it could be the plaintiff, the injured party, or it could be the insurance company who actually hires the doctor or the whatever type of physician to do the evaluation, the examination, and give opinions. Another occasion may be where the court, the judge in the case, let's say that it's a case of a Social Security disability appeal. The judge, the ALJ, the administrative law judge, may not be fully clear on what the actual diagnosis, what the actual injuries are. So the court themselves may hire someone and ask for them to do an evaluation. And the same can be said in a disputed work comp claim. Additionally, it can happen in a personal injury case.
Bernard, who is the, I'm sorry, let me know if we're finishing up the thought there, but I did want to know, my experience has always been predominantly defense or the insurance carrier is the one who does the IME. Is that incorrect assumption?
No, that's probably the majority of the time where it occurs. However, there's two other occasions where an IME may come into play.
Okay.
Sometimes when there is an issue, let's say in a medical negligence dispute, when one party or the other, and this is really kind of leans more toward the expert when you're being hired, but you're being asked to determine the causation of an injury. Now, again, there's a fine line between being an independent medical evaluator and an expert, and they really should not cross.
Okay.
Sometimes you may be hired in any of these scenarios to not only give a diagnosis, but also to offer an opinion of course of care. And that leads me to two issues, two things that before you agree to be hired, determine what you're being asked. What is your role? What are you being asked to do? And probably even more important, are you qualified?
So
a podiatrist should not be hired as an IME for a back injury.
Right.
I mean, I know that's an extreme example, but it's true, because your credibility, and we'll get to this part in a little bit, your credibility is what this is about. If your opinion is not credible, then you're just wasting time. You're wasting everybody's time and money.
And because many of our members do IME as well as expert witness, this is a similar case that comes up in the expert side of things. If you're an orthopedic surgeon or a generalist, but this is a cardiology matter, I know that's an extreme example as well, but you're probably not qualified to do that, to opine on that. So it sounds like that's across the board for IME or the retained expert.
Nick, you can go to the next slide.
Sure.
When we're talking about the role of the IME doctor, and I'm not going to try to read off of these, y'all can read these at your own, is, in my opinion, dealing with these types of situations, is the IME doctor has an ethical duty to provide, and I'm going to read from some of my notes, an objective, valid opinion, which are well supported by clinical experience and education and reading and whatever other things you bring to the table, so to speak, regardless of which party has hired you or is paying. And let me step back. The true IME is when both parties split the bill.
Okay.
I have found that is, and that's the most rare. That's typically if a court is going to order it, typically they'll order that the parties split it in half, and whatever the opinion is, that's the opinion.
That would be truly independent, objective. It's split in half, and we just need an objective analysis.
That's about as independent as I've seen, and I want to share, and I hope that the listeners and those who are here in the webinar never get to this point, but we had a judge here in Birmingham many, many years ago who was our presiding judge. He had gotten to the point where he was so tired of arguments by counsel on both sides about one particular doctor in town having just the most outrageous opinions, that finally the judge in one particular case ordered for that doctor to testify in court at some type of a hearing. The judge took it upon himself to basically cross-examine this doctor and then issued an order finding him not only to be not credible for this opinion, but going forward. Basically, he ran this independent medical examiner out of business from doing court work. I don't know what happened to this doctor from a professional standpoint, but from a court standpoint, since I think 2002, we've not seen or heard from him because his opinions were no longer objective. His opinions had gotten to be so far skewed, really for both parties, that there was no credibility. There was nothing to back up his opinions from a medical standpoint, from an objective standpoint. And
so that's really a learning example for our viewers today, that, you know, the objectivity and what you base your opinions on, you know, keep your credibility, avoid wild or unsupported opinions, and you'll probably be able to continue practicing. It would be my take from that.
Nick, you can go to the next slide.
Sure.
Please keep in mind that this examination, what you're being asked to do, is not medical care. You're not creating a patient-doctor relationship. The typical or the expectation of privacy, and it's not going to be there for this purpose. You're being asked to potentially review some documents or even look at film before or after doing an exam. You've been given your marching orders, so to speak, but you're not going to be issuing care to this person after this particular request has been performed. Typically, what I have seen, and I'll give you the example in a work comp case, when an IME is ordered by a court, the doctor does the review of the documents and medical records, then they do the examination, and then they either will issue a written report if requested by the court, or potentially both of these things, a report, or they'll be given, they'll give a deposition, a sworn deposition that will be later submitted to the court for review. But then that doctor's involvement in the case, other than potentially testifying at trial live, which I don't think I've ever had that, but I know it's been done before, that doctor's involvement is basically done.
And as well as with the patient, correct? There's been no established doctor-patient relationship there.
Correct. And typically this is not going to go under insurance. It's not billed like that. It's paid by one of the parties or both of the parties, depending on the situation. But please keep in mind this: if this becomes a common thing that you end up being hired to do, your reports or your testimony are always going to be out there. So your reputation, your consistency, the basis for your opinions are always going to be coming into question. And there is no, like I gave in the example a few minutes ago, what I didn't say is this doctor who was found to be discredited and no longer qualified to give opinions, at least in our courts here locally, he had done hundreds of these so-called IMEs, mainly hired by the insurance company. And ultimately, not to get too deep into the woods on this, but they found half a dozen or 8 of his evaluation reports, held them up basically into the sunlight, and all he did was change the name, birth date, and the the injuries, but the opinions were basically word for word. It was so lazy. It was as if he just did a cut and paste. But that's extreme. That's far extreme.
And I will mention, though, in addition to that, what I've seen on a rare occasion, Bernard, is that when, as you said, these are public documents, when that stuff can be possibly presented to the medical board, that could backfire against your actual practice as well, or against your medical license. If the information is so glaringly wrong, you do risk being reported to the medical board. It's a rarity, but I have seen several stories about it throughout the United States.
Anytime a physician gives under oath testimony in any type of a proceeding, it's going to be shared by both sides and put in databases. So it could be 10 years later in a completely unrelated matter. You could be the treating physician in a case and you're being asked to give testimony about the injury causation, whatever it is. And that testimony you gave a decade before and you have long forgotten about it could be used as cross-examination material.
Mm-hmm.
So you've got to keep in mind that any of your opinions need to be based on sound reasoning, sound opinions. Always keep in mind this is not medical care, and remember your role. What are you being asked to do? What are you being asked to give an opinion about? Nick, you can go to the next. You're given, typically what happens is you get a phone call or an email. I'm going to make up a hypothetical here.
Sure.
I call a local internal medicine doctor. My client, we're getting ready for a Social Security disability appeal hearing. The medical care, the medical diagnosis for my client for the last 10 years is just all over the board. I'm calling up this internal medicine doctor and said, look, I want you to do a full evaluation, head to toe, and then give me an opinion on the following. Can this person work? What type of medications? And there'll be a short list.
Mm-hmm.
I've hired this doctor, so I'm paying for this opinion that later will be hopefully reduced to writing and then submitted to the Social Security Administration as supporting evidence in a Social Security disability appeal hearing. And we've done this several times. I've had occasions where the opinion has come back. I don't think that this is a permanent injury or a permanent condition, and that's okay too, because the criteria doesn't require permanency. I've had opinions where they've called or they've written to me. They're malingering, they're making these things up. And I would rather have spent the few $100s or whatever it is to learn that from a professional than I would to be embarrassed at a Social Security disability hearing when the AL judge says, you don't have the evidence, you don't have the medical proof. So I would much rather do that. There are several doctors here in town who, as part of their practice, they have an active practice, but they also do IMEs. And we'll get to the credibility part in just a minute.
Sure. Bernard, before you move, we had one question. This was preliminary to going live, but one question Lynn had asked, and her question was for a different state, so I'll only ask you kind of what the Alabama rule is. She was a legal nurse consultant. She wondered if she could video record or audio record an independent medical examination if she was attending with the injured party.
Well, that's exactly what I was just getting ready to address.
Yeah, right.
Thank you, Lynn. The answer in Alabama is yes, they can be recorded. In fact, sometimes the court may ask for it to be recorded if it's been requested by the court. Sometimes the other party may want it to be done. A lot of times, the hiring side, the hiring party, may not even disclose yet that this is being done, this exam. Now, again, that falls under a fine line between a hired expert versus someone who is just being asked to do an IME. But yes, in Alabama, they can be recorded. A lot of times I like to have them recorded because it helps me to watch the recording to really learn even more so than you would find from a written opinion.
Okay. It's good. And I think I would caution Lynn or other nurse consultants or medical examiners that you should really probably check with counsel that you're working with for local and state rules on this. Bernard, again, is registered is licensed in Alabama. So if you're working outside of Alabama, I would definitely communicate with your retaining counsel as to what the rules are on this.
When you're doing the examination, when you've gotten your understanding of your role and what you're being asked to do, you should create a criteria either in writing or in your head, and it may just be your standard protocol, what you do with the normal patient anyway, but you need to find out what the current symptoms of the patient are and what are the activities of daily life, and if there's anything in those ADLs that cause those symptoms. Again, that might be going to the causation issue. It might, and I caution, because sometimes these exams are very short, and that really hurts credibility when either the patient or the doctor themselves testified, well, I was only in the room for 15 minutes. The doctor never laid hands on me. The doctor didn't do X, Y, or Z. That's when the injured party is testifying. Then when it's the doctor's time to testify and the cross-examining attorney has the deposition and says, Mr. Jones says you didn't do this or this or this, don't you think that would have been helpful to your opinions? Then you're going to have to back up your opinions and why you did or didn't do certain things. Nick, you can go to the next. And that's where we get in. This is the big issue. Unless it's a situation where you've been hired by the court, presumably your bias or the presumption of a bias, a perceived bias, is not going to be in a situation where the court has ordered for you to be the IME physician. The parties are splitting the bill, and whatever the opinion is the opinion. It doesn't mean you won't be subjected to cross-examination, that's for sure. But most of these general, if you see here listed on this slide and the next one, most of these things are going to be relevant regardless of who hires you or who pays the bill. You only have one reputation, and whatever it is, it's going to follow you in the litigation and in the legal field. Just like most things in life, your reputation is going to determine how much you're hired, how much you're liked, how much you're in demand.
And I think you make one of the items that stood out to me in this, Bernard, was do not exclude info that favors one side, or rather the opposing side. If there is something that's favorable to the opposing side, you should make that known. And that was, that was pretty interesting to me because that also adds to your reputation and eliminates that and sort of avoids the bias.
If you recall my example from a few minutes ago about the doctor who was discredited, one of the local lawyers who had deposed him got into how much of a percentage-wise his work on a day-to-day, week-to-week, month-to-month basis was doing IMEs in comparison to being a doctor with a patient, a patient load. And I don't remember the statistics, but it was a very high percentage where he was hired as a hired gun, if you will, to give all these opinions. And they also got into the percentage of his income. Mm-hmm. They got his tax records. I mean, it went pretty deep, but he was an extreme case. Let's look at the other side of this when you're just starting out, which I'm presuming, without having without speaking with anybody in the crowd, you're just getting into this, or this is fairly new to you. It could be your very first case, and that's okay. It just shows that you're new to this part of your profession, but you're certainly not new to what you've been training for and what you've been doing all of your professional life. An attorney may attempt to discredit you from a medical standpoint, but you have far superior education and experience on this. And that's why I said earlier, make sure that it's an area of medicine that you have the experience and education you're qualified to give opinions on. Because if you're asked to give an expert opinion, which you basically are as an IME, even if it's your very first case, you still can be prepared and do a very good job. Now, you may have a seasoned lawyer who may try to attack you, but you'll prepare for that with the lawyer, or you'll do it on your own. And I'll be glad to, I don't know if we mentioned earlier, but Nick will give out all my contact information. I'll be glad to speak offline after the webinar with anyone about this issue. Because again, a lot of these things, it doesn't matter what state you're in, they're all applicable
Right.
overall. Go ahead, Nick, I'm sorry.
No, I was agreeing with you. Many of the general principles are applicable across state lines, but you do want to talk with counsel about the local or particular jurisdictional rules.
Depending on your state, depending on if it's federal court versus state court, there is a line of cases, and I won't get too deep into this. We call them the Dalbert cases. And it doesn't matter if you're a medical expert or if you're an engineering expert or a golf course expert. There's a criteria that if you're held out in the case to be an expert, you have to convince the trier of fact, the judge typically, that you qualify through the Dalbert standard. Mm-hmm. When you're hired in a case, your attorney will talk about that with you, and that's spelled D-A-U-B-E-R-T, Dalbert. And it may or may not even come up. It doesn't come up in Social Security disability appeal cases. The court it's a completely different standard, and as long as you have actually done the evaluation and issued opinions, typically they're permitted to be submitted as medical evidence. Excellent. You can go to the next slide. Actually, you can go to the next one.
Next one, sure.
Yeah. Anything that you write down and communicate to third parties, like when you're communicating with a lawyer, anything that you write down as notes before the evaluation, while you're doing your research, while you're looking up something, anything you write down is discoverable, meaning potentially you're going to have to disclose it to the other side in the case. While I'm not going to go very far with that issue, the less you write down, the less that's discoverable, the less time you're going to be in the cross-examination hairs of another lawyer.
And this is applicable for those of you who also do expert witness work or who are new to it. This is applicable. This is why the attorney will probably request a telephone conversation rather than emailing your insights about your first impressions of a case.
For an IME, though, there usually is not going to be many communications other than calling the initial phone call to see whether or not it's something you want to do. Then you'll receive the medical records. Typically, the lawyer's office will just email them over in PDF form or hand deliver them, just depending on how many records we're talking about. Right. Then, depending on what you're asked, either you're going to be writing an opinion, a report, or you're just going to be calling a lawyer to give an opinion. And then eventually you may give testimony either in a deposition or in court. And when you're when you give direct exam or when you give cross-examination, you're going to have to defend your opinions, whether it's based on your expertise, being your experience, your education, the fact that you've diagnosed and treated this particular injury over the years, whatever the criteria is, you've got to be able to be prepared. And it may just be second nature to you, but it's not going to be second nature to the parties involved. So you're going to end up having to really break it down on a very elementary level of explanation. But don't ever assume that the attorneys involved in the case aren't fully informed on whatever the issue is about a particular condition or treatment or care, because I'm sure they've done their homework. I'm sure they have friends who may be specialists just like you and will have consulted with them. Mm-hmm. Never underestimate what the other party or the other side knows, meaning don't take it lightly just because it seems pretty second nature to you.
Right. And I think this was interesting here in your third item here. If the treating physician, this could come up in direct examination or direct and cross. The treating physician may have received input from fellow doctors, whereas and that could be important to how they diagnosed the issue, whereas the IME doctor is relying on their own opinion. So that is something, it sounds like that's something that one of the lawyers could be using to potentially impeach or rather to improve the standing of the treating physician's diagnosis and treatment.
Remember, it goes back to your credibility. You only have your own opinions really to rely upon. If you're asked a question, whether it's in cross or direct, if you're asked a question, be brief. If they say, and this is the example I give my clients, so forgive me if this sounds like I'm talking down to anybody. I'm not. I'm just trying to be very direct about this. Dr. So-and-so, what time is it?
Oops, sorry.
It's okay. What time is it? Well, it's 10:18 a.m. after you look at your watch. Don't tell me that your watch came from your great-grandmother from somewhere in Europe and it's special because of this. And 3 minutes later, you've told us the whole history of the watch. Well, what you've done is now created another 20 minutes of questions, none of which the attorney who came in to take your deposition had even thought about. And all it does is hurt your credibility. There's nothing good of it because you're so far afield from what the original issue was that it just waters down your opinions.
Good advice. Did you want me to go back to the other slide, or is this one?
Let's go back for just 1 second.
Sure. Ooh. Going the wrong way here. There we go.
Lack of experience. That's what I wanted to talk about.
Okay.
Lack of experience, it could be one of two things. One, it could be that you lack understanding, that you lack experience being involved in this process of being the IME physician. And own up to it. But what you don't lack of experience is what you do for a profession. But this other part, the lack of experience, limited understanding of nature and extent of injuries. If you get in there and initially do your review of the records, and then you do your examination and discussion with the patient, and you truly, this is outside of your expertise, your experience, tell that to the lawyer who hired you, tell that to the court. Again, your reputation is what's at stake, and that's the only thing here that should matter for you. By admitting that, you're actually strengthening your reputation. Absolutely. Too many doctors think, well, this area borders on what I know, so I'm going to throw it out there and sound good, throw a bunch of big names and information, but they know it doesn't take much.
Yeah, good advice.
Yeah. All right, Nick, you can keep going.
All right. And we got about 14 minutes here, Bernard, before I'd like to take some questions.
Well, I think we may get there a little bit more quickly. If you're hired by one party or the other to give this IME, all prior IMEs all money that you've made, all of the history that you have, just like I was giving that extreme example about that doctor earlier, all of those things can be discoverable in a case. Your CV, any speaking engagements, any, excuse me, any history that you have with litigation, if it's asked for, it's discoverable. Now a lot of doctors I know who really are more on the expert side of these cases, they don't keep any of that stuff on purpose. Mm-hmm. Lawyers do. They keep databases on those things. But just be aware, a talk you gave 14 years ago that's counter to the opinion you're about to give is going to come up. You got to be able, and it may be that the medicine has changed. It may be that there's many factors for the reason why your opinion is now 180 degrees from what you gave 14 years ago in a talk. I know medicine changes every day, every week, every month. Mm-hmm. But a good attorney will help prepare you for that. But again, that really is more along the lines of when you're an expert, but it can come up in IMEs.
Okay.
You can go to the next one, Nick. We may have gone over a lot of these things, but I'll give you an example. About 6 months ago, we had an IME in a work comp case. And in Alabama work comp cases, I think we may be the only state in the country that doesn't have juries, that doesn't have an administrative process. We're still litigation based, and it's decided upon by a judge. There's no jury in a work comp case in Alabama. We had a doctor who we hired to give us an IME, give us an opinion on causation. Now, it really is, it's borderline whether this was a hired expert or an IME, but it was, the court took it upon, because there was a dispute. I still don't know how the court, I guess the court took it upon as an expert, so we'll go that route.
Okay.
Well, we had this doctor testifying that the back injury was related to the traumatic event that occurred. Well, on cross-examination, the lawyer had 2 prior depositions that doctor had given a few years beforehand as a treating doctor in those cases, and was able to effectively, I thought, cross-examine our doctor who we had hired. And it gave the judge just enough pause to not give us everything we wanted in the case. So things such as how much money you're charging in this case, what percentage of your income comes from being involved in cases. And as it says here, you never want to have the reputation of buying or selling opinions. And that goes back to the reputation.
And I'll add in here, Bernard, that just today, before we started this webinar, I read about an article where there's a $1.5 million judgment for the plaintiff, because the defense experts, a radiologist, when they got to the point that they actually had to subpoena him to come and testify because he claimed to be out of state and had caused a few problems along the way, and don't think this person was going to necessarily testify to begin with. They subpoenaed him to come and testify. Then they asked, while he was on the stand, how much did you charge? And it was $58,000 for his report and his testimony, which was higher than any of the other defense expert witnesses. And that was what the plaintiff's counsel believed was the nail in the coffin for the defense's case, because it was so outlandish that nobody had ever heard about somebody charging this much for a very actually simple opinion to support the other experts, that it really harmed the case. And it looked bad on the expert. And I'll email that to people, the article that I found, if they reach out to me afterwards.
Again, I can only speak for my experience in the Birmingham Metro in the state of Alabama. We have cases statewide. An IME typically is going to charge $400 to $500 to do the evaluation and to issue the report. If the person is then called upon to testify, there's another hourly rate or half a day rate, depending on what's involved. Also, if the court is going to appoint a particular doctor, the court will typically set the rate to be split by the parties. And the judges are not just going to blindly come up with a dollar figure. They ask around. If you're new to this, if this is something you're just getting into, talk to some of your colleagues who do this kind of work. The more experienced you are in your profession, I don't necessarily mean in doing this type of work, but the more years you have in your profession, the higher up you are in your local community within your profession, you might be able to charge a little bit more, but it's all relative. A case that someone in our Birmingham market's probably about $1 million, $1.2 million in the metro area. You can't charge as much in a small town of, say, Troy, Alabama, which is 30,000 people, for the same type of a case. They can't afford it. It's just not
feasible.
It's not. A case in New York, of course, is going to be more expensive because everything is more expensive. So it's all relative. It really is. There really is just a few other items to go over, Nick, and I'd be glad to field any questions if there are any out there.
And would you like me to go to the last slide then, and as you wrap up, so your contact information is available, and then we'll please start delivering your questions in the Q&A box while Bernard wraps this up.
Yeah, that's fine. The thing I was going to say is if you get into this and you start doing it, be cautious, as I've said earlier, your ratio of the percentage of your income, the percentage of your time that you do these type of cases, whether you're an expert or asked to do an IME, in comparison to your actual patient practice. Mm-hmm. Because you're going to be disqualified immediately, and you may not even be able to testify at all if you don't have a practice, if you just do expert work. Because and again, I'm only speaking for Alabama, you may not qualify under that Dahlberg statute, or you may not qualify in the eyes of the court as an expert if that's the only thing that you do. And then it gets to your reputation as a hired gun, and then you'll be out of this type of work very quickly. Right. Just takes one deposition of being discredited to really effectively end doing this type of
Good input. We've generally seen a big change in the years that I've been with Experts.com. It used to be those doing IMEs or those doing expert witness work. Some could be, retired from clinical practice, but it is less and less that somebody's looking for, that any lawyers are reaching out to us. They're generally telling us, I need somebody who's active in clinical practice.
There's one more area that I wanted to bring up it's related to this, but it's not specifically for IMEs. There's an area in work comp in Alabama and other states called utilization review. And at least in Alabama, the insurance company, regardless of what's going on in the medical care, when it's approved or unapproved, not approved, they have the right through our administrative code to send off these records to have them reviewed, and typically it's going to be an out-of-state doctor, reviewed to see whether or not the care that's being ordered, an injection, for example, is reasonable and necessary for the medical care of this particular injured worker. And you may find yourself on a utilization review panel to be chosen to give those type of opinions. It's almost like an IME situation, because you're going to be asked to give an opinion after you review medical records, reports, or deposition testimony. Almost exclusively, though, and this is the big difference, is you'll never meet the patient. The patient will be in somewhere in Alabama, in my example, and you might be a physician in New Mexico. And you're being asked, you're an orthopedic doctor, a non-surgical orthopedic doctor, you're being asked, is this third injection of the last 7 months reasonable and necessary, or are there alternatives? And again, you're being hired by the insurance company to give an opinion that typically is going to be accepted or disputed in litigation, but you're being hired, you're being paid to give an opinion. It's a little different than an IME, but it's a very analogous situation. And all of the principles that we've already talked about in the last 30 minutes or so are going to apply to your situations as well.
Excellent. Excellent. Good. I forgot about the utilization reviews. We have a couple of questions here. Are you ready for them?
Go for it.
All right. I'm going to answer live. You should be able to let me know if that comes up for you, if you can see it, Bernard. We have Joanne asks, one slide stated medical exam may not be done during an IME. And she asks, how does the examiner give an opinion of a client's alleged injuries or conditions being treated without a physical exam?
Joanne, it may be a typo on my part, and I apologize. Of course, a medical exam is what they probably should have said was medical care is not going to be part of an IME. Hands-on medical exam will only give you more credibility. So I apologize for the confusion.
And I will have to take some credit for that because I did some editing of the slide, so it may have been on an error on my part. So I can't just blame Bernard, although I would normally try to. Donna asks, and we'll answer this one live. In your practice, who typically attends the IME with your client as their advocate? For example, she says, does the attorney do it? Does a legal nurse consultant, a paralegal, or potentially somebody else?
All of the above. It depends on your, it depends on what is being asked. It depends on who has hired the physician for the IME. It depends on if it's being recorded, video recorded or not. One of the better sources for us has been the spouse or the sibling, because we may have that person to testify.
I like
really,
that.
All of those people listed could be, or nobody at all. It could be that the doctor performing the IME does not need or want third parties in the room.
And do they in Alabama get that choice, Bernard? Can the doctor say, I'm not letting somebody else in the room?
Nick, I've only had one scenario where the doctor has explained, I do better when it's just one-on-one with me and X patient for this purpose.
Okay.
And what the explanation was given is, for example, that he gave, if the spouse comes in, the spouse ends up answering more questions than the actual patient themselves, who might not be a good historian, who may be nervous, who may be, because of their medical condition, may not have the memory.
I see.
Now, that doesn't mean that the doctor, the nurse, whoever's doing the IME, they can still talk with these patient advocates, after the fact or before the fact.
Okay.
I think it really is more of a preference by the doctor.
All right. So we don't have any more questions. I want to, we have a few more minutes, folks. I don't see any other questions here. I do have one question for you, Bernard, as a follow-up to that. Is there a time as as counsel representing the injured party that you feel that you need to be in the room for a particular IME? The attorney needs to be there. Or have you ever had that experience?
I did it once or twice when I was a younger lawyer, just to get a better feel for what was going on. But I don't think the doctors are very keen to that, particularly if it's just one lawyer, or as opposed to both being there, and then it becomes a show.
Okay.
I think that the lawyer may be best to stay out because the perceived bias that it may create, particularly if you're the one who's doing the hiring.
That makes sense. That makes sense. And Joanne asks another question here. Our
Joanne, I see
our
better.
demand, I just posted. I don't you should be able to see it now. Our demand for IME and response letters, part of accepted practice in Alabama.
I'm not really familiar with those two terms. It may be state specific. I think, are you from California? Joanne, typically what will happen is if the court orders it, there's a court order. And then depending on what the directions are in that order is how the physician will respond. Typically it's going to be with a written a response letter. I hope I'm answering what you're asking. But if it's one party or the other, there really is I don't know of any letters other than maybe an email that might go out saying, hey, Dr. So-and-so, can you do an IME for this particular injury or something like that? I hope that answers the question.
I think so. All right. Well, thank you, Bernard. We wrapped it up in just under an hour. Thank you to all our attendees. Again, this will be available on YouTube in the next day or two for those who want to see that. That's on the Experts.com YouTube channel. You can get there by visiting our homepage, Experts.com. Want to thank, I do want to take this last great presentation, Adele says. So thank you, Adele, for being here. I do want to take a minute to thank Bernard. And Bernard, thanks so much for being here. I really appreciate it. Again, our guest today was Bernard Nomberg, lawyer in Birmingham, Alabama. His contact information is on the screen. Thanks again, Bernard. I really appreciate you taking the time to help us out today and give our members some really great information.
My pleasure, Nick. And as I said earlier, if anyone wants to reach out to me, you can email me or find us on the web, and I'll be glad to talk about this anytime.
Excellent. Thanks again, everybody. Thanks again, Bernard, and I'll talk to you shortly. Have a good day, everybody. Bye-bye.